Okay, performance of the contract. This is another area where we're going to see two different rules, one for this chapter and then one that we apply to commercial contracts for the sale of goods, which is what we'll talk about in chapter 11 after this. Performance of the contract. This concept is all about the situation where somebody has performed some of their tasks that they're obligated to do under the contract, but they stop short of completing it. And the question is, when do I have to pay you for what you've done, minus whatever you haven't completed? And when can I simply walk away from the agreement entirely and not pay you for anything? And the question comes down to what's called, it comes down to your performance under the contract and whether that performance was considered substantial or whether it was not considered substantial, and your breach then is considered a material breach of the contract. The difference is, have you completely fulfilled, have you fulfilled basically the substantial portion of whatever you were contracted or hired to do, versus when have you just done the bare minimum maybe and left the party with the majority or the substantial portion to still complete on their own. So let's take a situation to think about. You have a contract to build a house, and the contractor begins work and digs a hole to start the foundation and then just walks off the job. In that situation, you're probably not going to want to pay them for any of it because for a lot of reasons they've left you high and dry and you now have a lot more to do. And that was not the substantial portion of your agreement. On the other hand, let's say they come in, they build the foundation, they build the walls, the structure, the drywall, and they get it all complete, except they don't finish the very last part of the roof. They don't finish tiling the roof. Well, in that case, that probably is a substantial performance because your contract was to get a house, and they've built you a house. The substantial part of the contract has been fulfilled, and so in that case, you're going to be limited to you're going to have to pay them for what they've done, minus whatever is left to be completed, but they're still going to be owed for what they've done if their performance is considered substantial. Now, what that means is going to differ depending on the subject matter and the situation and the context and circumstances, and also perhaps the jurisdiction that you're in. But most importantly, I think that it could depend on the contract itself. So this is a situation where this is something that's very important to spell out in your written agreement, especially if it's a long-term contract or it's a very large, expensive contract. The parties can agree ahead of time. If there's mutual consent to this agreement, you can decide for yourselves what's considered a material breach versus substantial performance. And that's really what you want to do. You don't want to leave it up to a court to decide that later on. So for instance, you could have there might be just one thing that for whatever reason is just going to be a deal breaker for you. And if you get the other party to agree to it, you can simply stipulate the parties agree that this X, Y, and Z is a material breach, and that's all there is to it. We won't owe you if you do those things, or if you breach in that way, we simply won't owe you anything else. Or you could agree that if that happens, we don't owe you for the whole thing, but here's what we owe you. That's called a liquidated damages clause, where you stipulate ahead of time if there's a breach or if this certain breach occurs, we owe you this much money, but we don't owe you anything else. And you can also define what a substantial performance is considered. Or if it's, again, a long-term contract that's going to take a while, you might want to set milestones in the contract that say, here's phase 1 of construction, and here's what's owed once A, B, and C is complete. Here's phase 2. And when D, E, and F is complete, and this is what we owe you from here. So that way, if a breach occurs, it's going to be probably around one of those thresholds. And so even if there is some difference, if they haven't completed one of those, haven't gotten to the next threshold, or they haven't completed that particular phase, there won't be quite as much for you to haggle over because you'll be within a limited zone of performance and money that's owed. Assignment, delegation, and third-party beneficiaries. Not going to spend a whole lot of time on this. Third-party beneficiary, what you need to know is that there are contracts that may name somebody in the contract who's supposed to benefit from something they're under, but they're not a party to it. Those parties will have the right generally to seek enforcement of that contract if they are a beneficiary under the contract, even though they weren't a party that signed on. If they're mentioned and they're supposed to receive some benefit, they're considered a third-party beneficiary, and they have some rights to that. With assignment and delegation, the important thing to note here is that if you do either one of these as a contracting party, you can assign your rights to another party, you can delegate your obligations, but that does not, it allows them to take over your rights or obligations, but it does not remove you from the contract. So if that person you assign, or particularly that person you delegate your obligations to, falls through, you're still the party to the contract. They're not a party to that contract. They're just a party to your delegation agreement. So that's just what you need to remember with both of these, is that you are still the ultimate contracting party. If you want to get out entirely, then what you do is you basically create a new contract, which is called a novation, and that's where all parties agree, including the party you're contracting with, to replace you in the contract, and then you can be out of it completely. Impracticability and frustration. This is an appropriate time to talk about this, because this is a concept that's going to be coming up a lot with the contractual obligations that people have or had existing before this outbreak of coronavirus, where because of the unforeseen nature of this pandemic, people are going to find it potentially impossible to fulfill some of their contractual obligations. The key here really is whether this was, and sometimes in contractual clause language, the clauses that deal with this we call force majeure clauses. You may have heard that term before, but what it basically deals with are what are called acts of God. And the reason for that phrasing is because the key is that something has happened that the parties couldn't anticipate. It wasn't something you could foresee. So, if the price of oil falls after you've already contracted to buy it at a certain price per barrel, that's not really unforeseeable. It certainly is frustrating, and it's going to make it hard for you to resell it at the profit you wanted, or you might have to sell it at a loss now. But you can foresee, we all know that prices change, that markets fluctuate, and so on. But a pandemic, unlike, I believe, anything we've ever really seen, that's not something that anybody was really anticipating, especially the degree to which it's going to sort of shut everything down. So there may be some people who will be utilizing this, and will have good reason to, because the purposes have been frustrated and their contractual obligations are now impossible to perform because of this unforeseen issue. So the last part, let me go back here. This chapter talks a little bit about damages and remedies that are available to you when you breach a contract. First thing I want to point out is that we have something with contracts called the economic loss rule. And what this means is that when your claim is simply a breach of contract, you're limited to economic losses, to getting damages. So you have to show what those economic losses were: loss of profit, loss of money that you had to expend to fix the issue, to hire somebody else when one party breached, and so on. Unlike torts, where you can get special damages, we call special damages like punitive damages, and to punish a party for acting recklessly or egregiously, and also things that are non-economic in nature, like your pain and suffering, for instance. That's not something that comes with a bill, like a hospital bill, where we can calculate this is exactly what the economic loss was. So you're limited to just economic loss with contractual claims, which is why if you do have a contract claim, what are you going to want to do? You're going to want to make sure you find some torts that go along with that. And there are some torts that pertain specifically to contracts, like and now I'm forgetting the name, interference with contractual relations or interference with prospective advantage. Those relate obviously to contracts, but those are torts. And so if you can prove those, you can maybe get special damages in addition to economic damages. We'll come back in the next chapter. We're going to talk a little bit more. We'll look at a case that kind of fleshes out compensatory damages and incidental damages and expectancy damages in a case in the next chapter. Liquidated damages I mentioned. Again, these are something that you're going to agree to ahead of time, that when certain things happen in the contract, when certain things go wrong, the breaching party is limited to a certain amount of damages, whatever that may be.